Hi, good evening. Welcome to Bar Talk. Tonight we're going to be talking about gun trusts and answering the question of how long people are obligated to pay child support. We're also going to have a special guest and bring to you a new hot topic. So with that, let's get started. Hi ladies, how are you tonight?
Hi,
Good
to see you.
Good to see you both as well. Long time no talk. So Ish, I'd like to talk with you starting child support. How long are people dealing with that, and what is the end game in the child support business of when people can stop writing the check?
I get this question a lot. People wonder, will I have to pay child support forever? And the answer is usually no, but of course, since we're all lawyers, we know that the number one answer in law school whenever your professor asks you a question was?
It depends.
It depends. Of course it does.
Absolutely.
So with child support, the name of the game is emancipation, and I know a lot of our viewers have probably heard about that term. But the question is, when is someone emancipated? And I think that's really fact specific, but there are some clues in case law and in the statute as to when that occurs.
So if you use the term emancipation, is there a difference between emancipation versus age of majority? So when a person turns 18 and becomes an adult.
Think emancipation means 18.
Right, so legally you are an adult when you're 18, but the obligation for child support may extend beyond that. Certain examples could be if you have a child with a disability, mental or physically disabled. Also, if you have a child that has continuing education expenses. So like if they're going to college or if they have some other educational goals that they need to accomplish, a parent might still be liable for child support.
So if you have college expenses, is that considered support or extra, like an extra support obligation that isn't based upon income but is based upon the expenses of the child? So is there a dividing line?
It is a little bit different, and I'm glad you brought that up. The courts look at that a little bit differently, and the way they come to a parent's obligation is arrived at a completely different method than with the traditional child support. So that is another topic for another day, but just so people are aware that if you do have a child that's over the age of 18, but they are going on to college, please be aware that your obligation to support that child may still continue.
So is there any scenario whereby a parent could refuse, I guess this is state specific, but can a parent refuse to pay the extra support obligation once the child support obligation ends at the age of 18?
So in Illinois, the answer is no. Of course, again, I would always qualify that with it depends on the specifics of your case. But in general, that support obligation is going to continue if the child is still enrolled in a four-year, college, or, there are all of these qualifiers that we use in terms of whether or not the parents are still obligated.
Would the support payment remain just the same if a child enrolled in college, or they're always going to modify it based on the new
Absolutely. So when we talk about emancipation, it's usually when the child turns 18. Other factors to consider is if the child is still in high school. So if you have a high schooler, you're still obligated to pay child support until they turn 19. So it's going to be 18, or if they're in high school, then that could be extended till 19.
Do you mean if they're still in high school as of their 18th birthday?
Correct,
I see.
absolutely.
Okay.
The other things that could maybe cause emancipation to occur is if a child gets married or maybe they join the military, the court will terminate your obligation upon any of those factors occurring in the child's life.
Let's say your child is 18 in high school and then enrolls into college. Your support obligation is going to continue. Is it going to continue just as it had been for all those previous years, or are they going to modify it depending on the new circumstances?
The answer is it will not continue as previous. So the Illinois statute says that they're going to look at, without absent, a prior agreement of the parties, they're going to look at what each party can contribute to the college expenses, right? Okay. So they're going to look at the child's ability to contribute. Are they going to get a job? Will they have scholarships? Will they take out loans? And all of these things can be factored towards resources that the parties have available. And then they will look at the resources of the parents as well.
Interesting. Well, it takes us, a lot of kind of try and different attempts to get people to get the right information in terms of what they do in their particular situation. So with that, we're going to go to break, and we'll be back in just a few minutes to talk about gun trusts. Welcome back. Glad you could join us again. If you missed us before the break, we're going to be talking about gun trusts, and Dana's going to talk to me and Ish about how gun trusts can be used as tools in estate planning and in real estate to help protect the interests of people with guns and their assets. So Dana, tell me about a gun trust and what that is.
Well, gun trusts have come into national media. I don't know if you guys have heard. There's been some controversy about them because they are an entity. It's a trust, just like when you think of a living trust or a land trust. It's a type of a trust, which purpose is to hold title to firearms. Now,
I'm sorry, is this really necessary?
What do you mean?
Do people really need a vehicle to hold title to their guns?
Well,
They think they do,
There's
obviously.
an advantage because firearms are classified as Title I or Title II. And just to keep it very simple, Title I firearms are your typical handguns. Title II firearms are, your guns that are more dangerous, more
Semi-automatic versus automatic.
machine
Okay,
guns,
okay.
silencers, things like that. Sawed-off shotguns, all that falls under Title II. So federal laws govern who can buy, who can transfer, how much tax to pay, and there is a difference in these federal laws between Title I and Title II.
Where are the differences promulgated by the lawmakers creating that differentiation?
Yeah,
or, okay.
Congress enacted these acts. I mean, and these go back even, to the early 1900s. And so these laws were enacted, I mean, more or less for, the protection of our nation. But the purpose of these gun trusts has come into play because you can have a trust have title to this gun, which then makes title, ownership, transfer subject to the law and follow those laws.
Wow, that's fascinating. I had no clue this even existed. Do most people know about this?
Well,
Well, I mean, if you're owning guns, you probably have.
Oh, that's why I
Right.
have no idea.
but is it something that is becoming increasingly popular because people are trying to shield their ownership interest in a weapon and using the trust as a vehicle? Or do you see it more in an estate planning context?
The controversy has come up because, do you remember that headline about, I think his name was Chris Dorner, he was a Navy SEAL or a reservist, and he had murdered some people, committed suicide
Yes.
with, it was a Title II weapon that he used, and he had used a gun trust to purchase that weapon.
To avoid the background check?
When you use a gun trust, you do have different requirements in the transfer application process. One thing that is not required of trust applicants is you don't have to submit fingerprints and you don't have to get a signature from
So why would that be?
a local
that doesn't make any
officer.
sense.
Because
That
people
doesn't
don't,
sound safe.
in my opinion, it's because people don't know about it. Because if there were more, not that attorneys or anybody is shielding that, it's that it's not popularized yet, it's not well known. The average person buying a weapon wouldn't,
But why
think
wouldn't the legislature think of that when they were enacting these laws?
because the legislators' children aren't the ones getting killed.
Well, when the legislature is enacting which laws? I mean, the trust laws are enacted, from an estate planning purpose and as a mechanism to avoid probate. So these gun trusts are now available to people who own guns in order to set up a system where their gun ownership can legally transfer and be distributed to their heirs, reducing the risks of running afoul of federal laws. I mean, gun trusts have a kind of a valuable
why
and
should estate
proper purpose.
planning have the ability to do that without further oversight?
I agree.
I don't know that the legislature foresaw that gun trusts could be used, to
For evil
Circumvent.
instead of for good.
Yeah, and I think that is part of the controversy is that you do have people who say, well, we have this situation now that creates a loophole, and so they want something done about it.
I think that makes sense.
I think
mean,
I'm one of those people. Can you help me out?
Well, I'm not in the legislature, but call your congressman, see what you can do about it. But gun trusts are around; they serve a good purpose. I think that there could be some tightening, of the laws surrounding them because the rules are different for gun individual transfer applicants and trust transfer applicants.
Well, I think a lot of disclosure and some additional research is necessary to figure out whether
Right.
or not there is a problem. I mean, if the public by and large isn't using them for the purpose of shielding,
Well,
we have to look at the percentage
mean-
of where is the trust being used as a vehicle for isolating information versus just legitimate purpose,
how-
because there's
let
no
me
reason you
point
can't
out
use
as well that gun trusts are typically used for Title II firearms. The vast majority of crimes committed with firearms are Title I firearms. The vast majority of firearms that people own are Title I firearms. Title II firearms are not commonly owned. I think I read a statistic that says only 2 crimes were committed since 1934 with a Title II firearm. So you're talking about a
but
very...
is a Title II firearm anything that's semi-automatic or with a silencer, I thought you said?
Title II firearm would be things like machine guns, silencers, sawed-off shotguns,
Dylan
any
Roof
other
had-
weapon.
Didn't he had a handgun, but the Sandy Hook was with a machine gun.
Well, I think the concern is those are the weapons that perhaps could cause the greatest amount of damage if they got into the wrong hands. And so,
Absolutely. I
Yeah.
mean,
so
absolutely.
using a gun trust in the situation where you're dealing
Right.
with such a deadly tool is just a little concerning.
Right. But gun trusts have a lot of advantages. For the legal individual who owns these firearms and wants to reduce the risk of subjecting any fiduciary or any beneficiary to a federal crime, they can use a gun trust to avoid that. However, we do have this controversy because gun trusts do have different transfer application requirements, and so because they don't match, we have the...
Well, let's hope it doesn't take a national news story to get the laws changed and maybe have the trust statute amended.
Yeah, well, I think they're definitely, it's in the news. It is a national news story, and I think it's come up in the legislature even the New York Times has discussed it as a legal loophole. So it's certainly.
There's an awareness now.
Yeah,
Right. Well,
that's basically what I'm trying to say.
We've got to nip the problems in the bud, and we have to nip the segment in the bud. So with that, we're going to go to break, and when we come back, we're going to meet Attorney Ross Hausman. Thank you. Hersman.
5, 4, 3.
Welcome back to Bar Talk. If you missed us earlier, we are here with Ish and Dana, and tonight we have Attorney Ross Hersman, who works in Chicago in the area of gaming law and intellectual property. So with that, Ross, welcome to Bar Talk. Glad you could be here with us
Thank
tonight.
you so much for having me.
So we want to talk to you about video games, and Sonic the Hedgehog I see is on your necktie.
Of course.
Awesome. So tell us a little bit about your practice and what you do here in Chicago.
Well, I work with independent video game developers right here in Chicago. A lot of people don't know that there's actually a very vibrant video game community here in Chicago. It's not just on the East Coast or the West Coast. But I work with mostly independent game developers and handle their business incorporations, their trademarks, their copyrights, or any kinds of other legal
So
issues
when
that
they
they might
come
run
to
into.
you, they have their game in concept in their mind, or they have it programmed out and they're like ready to roll, or
They're
what's-
usually ready to roll. A lot of times when they come to me, they already have the idea, they have the game, and they're almost at a stage where they're ready to take it to a Kickstarter or they're ready to publish it already.
Okay.
And unfortunately, that's kind of when they start thinking about legal protections. That's when they worry about, oh no, can I actually get a trademark on this
And is
name?
that too late in your opinion?
Sometimes it can be. So I try to be proactive and find them first so that I can say, here's some planning that you have to do before you actually make the game and invest all this time and effort into making something that you might not be able to publish.
Is one of the critical issues is ascertaining whether or not there's another like-kind game?
That's a similar thing. A lot of times it can be just as simple as the name, having a name that's already taken. I know a lot of clients who had to change the names of their projects because it was something that was already taken. But a lot of times there's games that bear too much similarity to other games that are already out there, and you run into problems with that as well.
So how did you choose this area of law? I'm really fascinated. I don't think I know anyone else who practices in this exact niche.
Good luck is what I always say. I was a gamer before I was a lawyer, and I loved games. And when I found myself in law school, I realized that this was actually an area that you could focus in. This was something that people needed because video games as an industry are a multi-billion-dollar industry like any other, and they have just as many legal problems as any other business, if not way more so, because video games are inherently so complicated. They implement science and art and technology in ways that no other industry has, as far as I can tell. So their legal protections are very complicated, and there's a whole new industry of lawyers trying to cater to their specific business needs.
And so once they've contacted you and you've helped them get going and you've kind of worked out all the kinks, Do you stay on board as counsel for the gamer? I mean, not the gamer, but the gaming
For
company?
the developers, it really depends on the project that they're working on and what their end game is. A lot of the people I work with are actually students at some local Chicago colleges. They make games as part of their game design programs, and then they have to decide what they want to do next. So some people I work with are just kind of divvying up the rights for a project they may have worked on with 5 other people. Some, their end goal is to take it to a major publisher, and I always try and stick with them as long as they need me or as long as they are still working on that project.
And then what sort of issues come up down the road? I mean, let's say someone sets it up properly with you, and then, you know, life is great, everybody loves their game. What sorts of things have you seen come up in?
It can be great things, it can be terrible things. Some of the great things that can happen is if you have a game that's really, really popular, someone wants to buy it from you, and then you have to worry about acquisitions and licensing and all kinds of business contracts. And a lot of game developers, they're artists and creators first, they're not lawyers. So that's the kind of expertise I try and help them.
They're probably not even business people necessarily.
No, but you know what? They're a lot smarter than I am, I have to tell you. The way that they can turn numbers into artwork, it fascinates me every day. But then on the other end of the spectrum, sometimes they run into problems where, like I said, you may have a game that's too similar to another game, you may have a licensing issue, or you may have collaborators working on the same game who have different ideas for what the future of that game should be, and you start getting partnership disagreements, and that's where they kind of have to have a third party to come in and kind of mitigate the problems that they're having.
So since I do a lot of business litigation, my question to you would be, does the existence of the gaming and these issues of licensure and partnership agreements, does that spurn a lot of litigation in your viewpoint?
It does, and it really depends on what kind of game you're talking about, and as always with law, dollar kind of controls. So I think that a lot of the clients that I work with are a lot more willing to cooperate and kind of find a amicable solution to a problem without going to court. So there's a lot of settlements involved in things like this. So that's a wonderful thing about game law, is that sometimes people are more willing to cooperate with each other because the end goal is to put out a product and to share art with people, not necessarily to make a profit, though that's always nice to have on the side.
Nice icing on the cake. Well, that's really interesting. What do you do in your spare time?
My spare time, everything I do seems to be wrapped up in games somehow. In addition to doing my legal aspects with video games, I'm also the president of the Video Game Art Gallery here in Chicago, and we're a nonprofit organization that works with video game artists and helps them showcase their artwork, and we help fundraise for local artists so that they can keep making what they make and sharing it with everyone.
That's great.
That's really great. Well, thank you so much for being a part of our show, and we'd love to have you back again another time, and you can tell us what interesting things you are working on. So with that,
I love that. Thanks for having me.
Thanks again to Ross for joining us tonight, and we'll be back in just a minute.
4,
Am I supposed to be able to see myself?
not yet.
Okay.
3, 2.
Hi, and welcome back. So tonight, for our hot topic, we're going to talk about the recent on-air shooting of Allison Parker and Adam Ward by their former coworker in Roanoke, Virginia. So, ladies, have you heard about this terrible tragedy
Very
of last week?
tragic. It's just
Yeah,
awful.
yeah, it's
So
unbelievable.
I think that it brings into kind of focus so many different issues of violence, but this was a former coworker who didn't appear, from what we know now, to have any specific issues with his victims in this crime. Have you ladies heard anything that he had any problems
I
with
thought
them
that
specifically?
he did have problems with her.
He did, but it's really vague how much really took place in this man's mind and how much was real and part of real life.
I heard from, or when I was watching the CNN coverage, and the station general manager was explaining the gunman's employment history, that Miss Parker was an intern at the time. So I think they knew each other, but I don't know that maybe she was an intern when he was the newscaster and doing his journalism work, but I don't know they worked much
he
together.
really felt persecuted. I mean, this is a man who felt like he couldn't get a break in life and everyone was against him. He felt attacked by people. He thought people around him were racist and were out to get him.
Do you think that, was there any information put into the media about any mental illness?
My understanding is there's no official diagnosis, but
Yeah,
psychologists
I don't
who've
know.
read about him and who've been following the news tend to think that we could have a little bit of narcissism going on here.
Certainly. I mean, it's my understanding he had multiple cameras that he shot himself, and I heard a recent commentary that he produced this whole murder, and it's really just, it highlights the issues of instability in the workplace and the kind of the ongoing theme of the access to guns and these senseless murders that, and even in this case, people weren't sure of what was happening as it was happening back in the newsroom. Some people thought that it was fireworks. So
Well,
it's
you bring up this issue of safety, and I think that's an important piece of this to me is how can we keep employees safe in the workplace? And people talk about how she wasn't sent out to a war zone, you know, she's just down the street covering a
Right.
very local story. Is there anything we can do to protect ourselves and our coworkers?
Well, I suppose it begs the question of if you see a person who's fired from your place of employment and why was he at the scene? I mean, why were they doing that shot in an open area? They could see him coming from another direction. I wonder why there wasn't the ability of her, Mr. Ward or Miss Parker to stop tape and
well,
wonder
if
what
you
was
think
happening.
about it, they're
maybe
doing their jobs.
Maybe they
they're
didn't
working.
see them.
They're in the
Yeah,
middle
I
of an
mean,
interview.
Do we
He's
need
got
to
the
have,
camera
it sounds
running.
like you're saying,
and
do we have to have security?
Well, that's what I'm wondering is because, again, he clearly wasn't supposed to be there. He was a fired employee. It's one thing if it's a stranger that neither of the victims knew, but because this particular person was a disgruntled employee who had been
no one
fired.
saw him, Elisa. They're working. They're not looking around to see who's walking up to them. They're busy. They're in the middle of a shot.
They weren't in a closet when it happened. They were out in the
Oh,
open.
I think that's a little unfair.
All I'm saying is that they saw him approach.
They
and
did not see him approach. They were working. If you watch the footage, she was interviewing her guests and she was staring at her guests.
But she's outside, and so if you see a disgruntled ex-employee, that's clearly a strange circumstance. I'm not saying she brought the violence upon her. I'm saying had there been another person there, like security, to say, well, what's he doing here? He's not supposed to be there, and it was 6 o'clock in the morning, maybe earlier. So it's clearly weird that he was there. If it's a stranger walking by with their dog, then they're going to do their jobs and continue because professionalism dictates that. But when a deranged ex-employee comes who's not supposed to be there, I would think that they would have been at liberty to stop tape. They didn't have to.
Well,
but it's
I
clearly
agree. I don't think
strange.
that they would have even noticed. I mean, this is an employee. Maybe they didn't even recognize this
Right.
person if they had seen him, because this is somebody that had left a long time prior.
Right.
I mean, their minds are, completely in the moment. But it sounds like you're saying that we need to have security everywhere. I mean, people need to hire security guards to go to the grocery store, to go to their job, to take their kids to school.
Well,
Now,
that's
we
not
need
what I said. I mean, I'm
no,
saying.
but it sounds like you're saying that, because why don't
But if
we
I
have
well,
security?
I would just say that if I were saying that. What I'm saying is that there's nothing wrong with having security protect the newscasters. If we were living in a different type of society where that type of security was necessary, then it really would be a police
Well,
state.
when
I'm
we
not
think-
advocating for that, but what
When
I'm
we think about security, can we go a little bit further back in this story? I mean, the reports have said that he was a very difficult employee, that he was fired from multiple positions. Is there anything that could have happened earlier, perhaps?
Well, certainly it begs the question of whether or not WDBJ and Roanoke would have been able to find out his past history with his prior employer and why was he fired and were those issues. So there's a question that maybe comes to pass of was some of the information about his employment file discoverable, and maybe that would have stopped this hire. But I suppose it suggests that if he wasn't hired at one station with otherwise reasonable qualifications, he would have been hired somewhere else. So,
Maybe the answer is there is no way to protect yourself, and this is just the reality of our new world and the fact that people do have access to firearms and are at liberty to use them as they please.
well, to the degree that we have implemented on airplanes, we have air marshals and we have people that are standing by the ready after significant tragedies to be there and to protect. Maybe it begs the question of whether or not we should think about putting people, when an event has arisen at a specific workplace, could we take some steps to make sure, or should those employers take some steps to make sure that
Well,
their
my
people are
understanding,
safe?
just for the record, is they did have security at the TV station after he was fired. He had to be escorted out by police officers. Everyone was on edge for a while, but no one thinks 2 years later
I
you
would
still
agree.
need to be worried about this individual. And I think that's the most tragic thing, is there was really no way to protect themselves.
I completely agree. And even to my point just a minute ago, just to clarify it, even if they had seen him and stopped the tape, it's not as if they necessarily would have avoided the harm that ultimately befell them. But he certainly wasn't supposed to be there, and it was very strange. So gives us some food for thought for kind of analyzing this particular tragedy as well as how we deal with others in the future. So with that, we're going to go ahead and wrap up for tonight. But thank you so much for joining us, and we'll see you next time. Have a good night.
Good evening and welcome to Bar Talk. We're so glad you've joined us. Please pull up a chair. We have so much to talk about tonight. How's everyone doing?
Doing great. Good to see you.
Good.
Doing good. Good to see you.
I wanted to talk to you guys about a situation where someone wants to get married, or divorced for that matter, and they realize that they were not legally married to begin with.
So is that like the situation where someone runs off out of the country and does a destination wedding and forgets to legalize
Wait
it
a
in
minute,
the
they
U.S.?
weren't legally married to begin with.
Right, so sometimes people think that they were actually married and they never were. And that can be really devastating because now they think that they have recourse under the law for a division of assets, but if you were never really married, you don't technically have a claim.
So how does it happen that you're not really married?
Exactly.
The person who marries you wasn't licensed, or
No, they weren't available for marriage. So take, for example, if someone was already married, you can't just go get married again. You have to make sure you get a divorce of the first spouse first.
But who's really looking? If you're married in Mississippi and you leave your spouse and you move to Seattle, Washington, and then you begin your life anew and you get engaged to somebody else, you go to the courthouse and you fill out the papers in Washington to say never been married. Who's checking? Your old spouse?
Nobody is. Nobody is,
Right.
and that's a problem.
So how does it come up?
It comes up when this person now wants to get divorced. Maybe they did get married and they thought it was real, and now she wants to get divorced, and maybe someone just drops her a note or picks up the phone and says, hey, by the way, you're still married to my husband. And she's like,
You know what? It also comes up in probate because people get married in other countries, then they come here, they get married again, they never got a divorce. The spouse here thinks she has a spousal right. They find out in the former country that decedent died and has assets.
So it's like the
then-
trailing Haley's Comet
So
effect.
sometimes
It's the person
that's
coming
another
back.
way. Another way is on the border or if you go to what's it called when you want to be a candidate for public office, then they might do a background check and they might find
Okay.
out that way. Or so.
but I think you bring up a really good point. Is a lot of times people just don't know, and when they find out, it's not usually in the best case scenario.
Right, because well, if the ex is coming back to haunt you and you thought that life was good and gone, or a background check, is you know, and that's probably not that easy to remedy.
So what happens in the case? I mean, is it just tough luck? You know,
It really depends on the facts.
Is there any equitable resolution?
Sometimes courts will say if there was fraud. Now, a lot of this depends on timing, right? So if your marriage is invalid and you want to get a declaration of invalidity, a lot of people know it as annulment. They want their marriage to be annulled. What you're going to have to do is really look at the timeline. If you were under duress or there was fraud involved when you got married, then maybe you're going to have a recourse, but only for the first 90 days. And so if somebody was fraudulent and they represented that they were available for marriage and you find out 20 years down the line that they're not, it's not a great situation
I mean, look
to be
at Social
in.
Security. You know, you have a right to claim your spouse's Social Security benefit, but if you were never married to begin with, you know, for that period of time, does that spouse have any recourse? That would be inequitable, I think, if there would be no recourse.
I got a call less than a week ago from a very close friend whose fiance's father was on his deathbed, and the current girlfriend wanted to know if she had any rights to the house he lived in, and it happened to be that he lived on an Indian reservation. And I talked immediately about, you know, ascertain if there's an ex and figure out his marital status, because it would make sense for him to be able to figure out if he could get married on his deathbed, or what he wanted to do to try to transfer his rights, because he didn't have a will. But ultimately he passed before any move could be made in that regard. But yeah, I mean, you have to know whether you're married and know whether you're divorced.
Right, and a lot of times when people think of reasons to get annulled, it would be, you know, I was too drunk. I think Britney Spears had that story once where she went to Vegas and she was drunk, and you know, you can get that annulled quite soon after it occurs. You can state you didn't have the mental capacity to enter into a contract, right? And so some of those cases are a little bit more common. Another less common reason is if your partner is not able to consummate the marriage and you didn't know that before you married them,
But I
courts
thought-
also take that quite
But I
seriously.
thought part of what you were talking about is if someone gets separated and then they move on and they just never get a divorce. So that
we're
arises maybe in
talking
sort of a
about-
different way, right?
Right. It's the same umbrella, right? A marriage is not valid. It's not legal, and it can be invalid for several reasons. And some of it is because the person wasn't able to enter into a marriage legally, and the reasons for that could be mental capacity, but could also be they were already married. And so I'd like to just sort of highlight for people some of the lesser known reasons that you might run into trouble thinking you're married, thinking you have certain rights under the law, when in reality you don't.
Well, it's always good to be well aware of your circumstances and to make sure you surround yourself with good information wherever that comes from. So
Exactly. So ladies,
know.
take away, make sure before he puts a ring on it, he's actually able to.
good advice.
Thanks for joining us. We'll be right back.
Three, two.
Welcome back. Thanks for joining us. Elisa, I have a question for you. I've heard this term of a receiver, and it has something to do with building code. Talk to me about that.
It's increasing in popularity in the city of Chicago and a lot of large metropolitan areas. A receiver is common also in the mortgage foreclosure context. So this individual or a company can come in and get appointed by a court to take over property. So in any kind of context when a property has code violations or is dilapidated or the owner's unable to care for them, it's kind of like a guardian but for a building. So the receiver can come in and be appointed, and they can get court permission to make repairs, to evict tenants, to take over, stabilize the property.
Wow. Isn't that like, remember that movie, The Soup? That was a good movie.
I don't think
Isn't
I saw that one.
There's a role, there's a person whose role is to be
The super. Oh,
Yeah.
okay. So, well, no, a building super is like a building manager. So yes, that's their job. But if you're a homeowner and I'm in the city of Chicago and I have given you a code violation and you either don't get it or you fail to take any action, and somebody in the city of Chicago building code inspection team or the Department of Law feels that your building could be suitable for a receivership, either in cahoots with the city or because of relationships that the receivers have, they can get appointed. So
So when you see that orange sign or yellow sign on the door that says there are violations with this building, is
That
that a
doesn't-
situation where a receiver would be appointed?
could be appointed. It doesn't, anytime there's a building code violation, the city will inform the property owner. But the reason that it's interesting in the context that I want to talk about it is that when a building code violation is levied, it may or may not be significant over the long term. I'm thinking of a case where, like, if the heat doesn't work, and it's the springtime, so there's still time. The tenants don't necessarily need as much heat in the spring and summer as they might in the winter. Which naturally we can imagine. But a receiver could be appointed at any time of the year to take over the building if the owner is unable, unwilling, or if the city thinks it's necessary.
I'm
or
sure landlords don't take too kindly to this.
they don't, and here's why. Is because when the receiver is appointed, they can take any act they deem necessary. They can spend any amount they deem necessary, and then not only will a court, in many instances, grant them those expenses as reimbursements.
And the owner's on the hook for those costs?
Owner's on the hook for that. Here, it gets worse. Attorney's fees can be levied, so whatever, even if the receiver doesn't need an attorney to actually do anything, they can get attorney's fees. And a receiver can jump in line ahead of any other lien holder, including a mortgage company, come in for as little as a few $1,000s. Say you have a property worth $300,000 and a receiver's only owed $5,000. They can come in and foreclose on the property and create a situation where the property can be sold.
That is
to
a lot of power.
It's
I can't
a lot
even
of
believe
power.
that.
It's actual. It's insanity, and what I see in the building court context is that in a case that I'm thinking of is that the heat was never turned on because the tenants didn't apply to the gas company for the gas accounts. So as a result, it made it look like the property couldn't be heated, but it could be heated fine. It's that the tenants didn't set up the account.
And it wasn't even the landlord's fault in that
Well,
situation.
wait a minute,
Exactly.
but it doesn't sound like that this should be a problem. If you have a case like that, the landlord would just go into court and say the tenants did not set up the account.
Here's why.
I don't need a receiver.
So the receiver, in the case that I'm speaking of, was appointed on March 5th and had everything done by March 15th before the homeowner had been served. So all of this took place.
So there's no notice requirement to the homeowner?
The notice requirement is the same for any lawsuit, which is just that he has to be served with the summons. The summons was outstanding against the homeowner because if what's very common is that in a homeownership context, there are multiple parties of record: the lender, the tenants, as well as the owner. So the tenants had been served and the lender had been served, but the owner hadn't yet been served.
So the
By
owner
time
doesn't have to be served before the receiver can do all of this?
No.
This doesn't sound right.
It doesn't sound right. It doesn't sit well with me, and it doesn't sound right. So at the point and time at which I inherited it was the point at which the receiver was trying to collect on $10,000.
So what did you do for them? How can you help people in this situation?
I analyzed the bills. I saw that this particular receiver was an accounting company, an engineering company. They had 4 uneducated inspectors who have no specialized training, who commanded over $150 per hour. So I made an argument that that was unjustified because they have no special degree beyond high school. I looked at their time record. Some of them spent no more than 80 minutes at the property, yet they charged for travel time. 3 accountants were on the file to do nothing more than Excel spreadsheet type work. So it added up to $10,000, and my argument, which will be made to the circuit court, is that it's complete gross excess that was an abuse of the court's discretion because it wasn't even necessary.
Wow,
But
really
this is after the fact
fascinating.
coming back in to clean it up. But if I can save my client $10,000 and I can improve on that potential damage by even $50, then I'm winning. So to the degree that this is something that can come up, any homeowner could deal with a receiver in the city of Chicago before they even know what's hit them. So
Thanks
happens
so much,
fast.
Elisa. That's really great information.
Absolutely.
We'll be back with more bar talk in just a minute.
Five, four, three.
Welcome back. So Dana, I have a question for you. Do you have something really exciting to share with us tonight?
Of course I do. Well, I wanted to know, have you guys heard about this case? It's called Safransky versus Dunstan.
Never heard of it.
I don't know that
The case decision came down in June, and this is a frozen embryo case. It came out of the Illinois Appellate Court. It's actually gone up to the Appellate Court for the second time. Originally, in about 2010, we have plaintiff and defendant who were at that time boyfriend and girlfriend. They had a relationship, and she wanted to have some embryos.
Frozen.
This happened to Sofia Vergara, the actress.
Similar story, right? Where in our case here, our female, Ms. Dunstan, she wanted to have her embryos fertilized and frozen because she was diagnosed with cancer and going to be undergoing chemo, and they were saying the risk of infertility was high. So she talked to her boyfriend, and her boyfriend agreed that he would be a donor. So ultimately they went through the in vitro process. They were able to fertilize 3 eggs, and they froze them. The relationship broke down, and she wanted to keep custody of these eggs, and he wanted to prevent her from using these eggs.
This is essentially a custody dispute.
That is exactly what it became. He filed first, trying to prevent her from using this. She counterfiled.
So like an injunction.
Right, and then she counterfiled saying, I want sole custody of these embryos.
So like a declaratory action to see what her rights were?
No, she actually filed for custody.
But how can you have custody of a thing that isn't alive yet?
I don't know.
Ish, our resident family law.
Yeah, I
what do
mean,
you think?
Really
This
in
is
a whole new world here. It's a very fascinating.
That's exactly the point, is that there are very few case law
It's not viable.
examples to go off of. I mean,
It's really a piece of property.
From
I mean,
a
if we're going to be
national-
honest about it, at this stage it's property, but it's important to have custody of that property because when it is born and when it develops into a human child, we have to know who gets to raise it.
well, I think those issues are all, they need to be worked out. I don't think they are flushed out. I don't think there's consensus on what the situation is or how it stands.
But if they had an agreement for them to be fertilized, is is there maybe a push to having the agreement be required in writing to show the parties' intent at the time of fertilization and to see
Well,
where
but the
they were?
intent at that time was that they would be together and they'd be raising these children as a family. So I don't know if going back to the intent is so useful under the circumstances.
But maybe it is, because maybe the intent was just to make a baby, and that's the real question: is was the intent to make a baby, but nobody was looking?
Well, it's interesting because
Yeah.
in this particular case, Ms. Dunstan, who just wanted to be able to have a child in the future, it wasn't necessarily with Mr.
Right.
Safransky. He was in the position at the time, and so she felt more comfortable with him. But that came back, all of those details came back into the case where he was saying, you know, I didn't sign up to be a dad. I was providing her this sperm as a donor.
But that's a ridiculous
now
argument. Did that win?
Now he is potentially liable for this child financially and ongoing
But-
as a parent.
But if from an
so there are a lot of
But from a legal perspective, if we intend the natural kind of evolution of our actions, then you can't go to the process of in vitro fertilization, do your deposit in the cup, understand that that's going to go inside your intended, and that she may get pregnant. That's the whole idea. How could he? Did that argument stick in any court that he didn't intend a child to come of that
No, it's
process?
not that he didn't intend a child. He didn't intend to be the father of a child. You know, she asked for a donor. She told him she was nervous about using an anonymous donor and that she would prefer that he do it. So from his standpoint,
He didn't make that connection that being a donor of sperm equates.
Well, there are such things as anonymous donors.
Yeah, I mean, he did.
Right, but he's not anonymous.
He did not have an intention to become a father. He had an intention to provide.
That sounds like malpractice
Dana,
if a lawyer
I need
makes
to
that
know what
argument.
happened in this case. Can you
yeah,
clue
me
us
too.
in?
Well, the recent. Let me give you the case history, and then real quick, I'll give you what happened recently. So the lower court, the decision went to her. Then he appealed it. The appellate court reversed the decision and remanded, saying that you need to use this hybrid method when coming to your conclusion. The lower court, the second time around, still determined and awarded for her, saying that there was a contract and that it was not it was an oral contract,
Right.
and that it was not otherwise modified. And then it went back up to the appellate court, and that's the decision that came down
So
in
it's all
June.
as a contract theory. Interesting. Okay.
And then the
so not family law. All right.
appellate court in June affirmed, held for her again, but it was only a 2-1. There was a dissenting judge who did not feel that there was a contract that had been created.
But that highlights the whole appellate problem, is that if you're talking about in an appeals case the existence of a contract, then you really stop talking about that underlying bigger picture family law property versus embryo issue.
I think this is great. It raises so many questions, wonderful things for all of us to think about, including our viewers. We'll be right back. Welcome back. Thank you for joining us. So ladies, have you heard about a recent case where a death row inmate has been granted parole, and there's all these questions about whether or not he was properly read his Miranda rights?
I heard a little bit about it. Can you tell me some of the facts of the case to bring me a little bit up to speed?
Well, what I understand is that there's a lot of issues centered around a confession. This man confessed to murdering people. However, we're not really sure if he was properly informed of his rights under the law prior to speaking to the police.
So he's actually guilty, but he is using a technicality of the Miranda rights to try to overturn the conviction?
There is no decision with regards to guilt or innocence when it comes to whether or not someone's constitutional rights were adequately protected.
No. You're saying, was he
It appears
convicted of murder?
He was convicted.
And he's actually guilty.
He was convicted, and there's been an
We
appeal.
hope that if he was convicted, he is guilty.
Well, but we don't
No,
know
I'm
that.
clarifying. That's what I thought you said. That's what
I don't think anyone knows, and I think that's why it's not relevant. A lot of people in criminal law get caught up on who did it and who really, and that's not the point. The point is the law is supposed to work in a very particular way to protect citizens of this country. And if there's a flaw in the justice system, it's something that needs to be addressed. And in this case, the question is, was he properly informed of his rights to counsel and to remain silent when he was apprehended by the police?
Well,
is
in
his
this
argument?
case, it does show that he was improperly informed. However, the facts of this case also show that he was high when he was told these. So had he not been high, he may have understood, and his improper hearing, I guess, of the Miranda rights may have made a difference. But because he was high,
Well,
I don't know that it made a difference.
Right. The obligation of the law enforcement officer is to give the rights. It's not to ascertain whether or not the person understands it. The Miranda right
but what's
is
the point if you can't understand
what I'm
but it
saying.
doesn't. But it doesn't work
Right.
that way. The Miranda right is you have the right to remain silent. Do you understand? You have the right to an attorney. Do you understand? You have the right to have an attorney present when you are questioned. Do you understand? Do you understand? And then they ask again. Do you understand these rights
So
as
how
I've read
can
them?
he understand?
Because that's his problem. If
But
he's
if-
high,
but
Wait
if
a
you
minute,
can't-
that's not that you cannot be the fact that it's his problem. I mean, the whole purpose of the Miranda rights is for his interest. There has to be some credibility given to the fact that if he is in a position that he can't understand them.
doesn't work that way. In the criminal law, the law enforcement obligation is to follow the law. It is not to practice medicine. It is not to ascertain sobriety or lack thereof.
No,
It
but
is
we're
not
in
to-
it. We're not asking the law enforcement to determine it. We're now at
Sure
the
you
point
are.
of the court case.
No, because that's
The
far
court-
too late. You're outside of the context of the crime. If the person can be exonerated from death row on the technicality long after the crime was committed, then at the end of the day,
Wait a minute.
you're-
We
the
are
only-
talking
the
about
only-
death row
the-
here. You
it doesn't
understand
matter.
that.
Well, again, I'm not arguing the fact that the Miranda right is necessary or not necessary. What I'm saying is that's the state of the law, that the right is to be given. The fact that the incapacitated would-be criminal doesn't understand it is not the only way to make that better is to go back in time to change the policy at which the law enforcement person is supposed to give the directive. You can't make their job more complicated in this day and age of last minute or split second decisions whether or not to use a weapon. They have too many things that the police have to worry about, which is what we're facing in the
but if you look at the totality of the circumstances, you've got a guy who's probably coming off a high, he's tired, he's hungry, he's going through withdrawal, and you're telling him that he has the right to remain silent, but somehow he just feels like going on and on and on and telling you all these details about this crime,
this
and you're going to
happens-
use that confession against him?
Absolutely, because the point is that anything that you say and do can always be used against you in a court of law, and that's true whether or not you're told about it or not. If we take this out of the criminal law range and we put it into a commercial law scenario, if you admit to me and I'm a witness to an agreement, to a contract, or oral contract, and then you admit fraud, that would be used against you in a legal situation in another way. What we say out loud can be used against us, personally
Well, that
and
is the point of
professionally.
this case, is
Right.
that what he said out loud is not going to be used against him.
After the fact he spent on death row, he got lucky. He's off death row. So it ultimately that's the end result, but that's not the goal of Miranda to free people from death row.
Right.
It's
So that's
to-
why this is an issue. That's why
Right.
we're saying, is this correct? I mean, if this person
I'm
who is
saying no.
convicted of a crime is let go because of a technicality, then is there a problem with either the law of procedure itself or the administration of it? I mean,
Both,
here
arguably.
it seems like it failed. If we have a murderer,
You
who
guys,
is-
you have to realize this is one case. I mean, the reason some of these cases stand out to us is that they're so striking in the way that they demonstrate some of the more basic problems with the criminal justice system. This is happening every day. It's happening
Absolutely.
everywhere. And so when you talk about systematic issues, I think we need to address them from the ground up so that there is a standard.
Well, part of it, though, is that in a death row or capital case, those have automatic appeals, where in the civil context, appellate rights are not automatic. They don't happen by operation of law. So there are a lot of differences in the criminal realm versus the civil realm that make these, because it automatically trickles up to
And
that
you know
apex
what? You're
point.
right. I know we could talk about this forever, but we're out of time. I'm sorry that we have to go. Thank you so much for joining us. We hope that you'll check out our Facebook page and please drop us a line. We'd like to know what's on your mind. Join us next time for more Bar Talk. Good night.